Hello, folks. Professor Schulman here. This is the recorded video for week 5, Law 3761, Negotiation and Mediation. This is the substitute video for the in-person lecture for that week. In addition to watching this video and then posting questions you may have, please remember you're also required to view the mock mediation video and make responses to the post I've put on the Twen site with questions and comments about the attorney and mediator ethics displayed during the process. Okay, so we'll go ahead and we'll get started with our lecture for today. As I mentioned, this is negotiation and mediation, Law 3761, week 5. Today's topic, we're going to discuss mediation. And so as you see in this particular slide, hi folks, Professor Schulman here. This is the video that you're to watch of the lecture in lieu of the in-person lecture, since I will not be able to attend class on February 10th. Additionally, remember that when you're done with watching this video of the lecture, you also have to go ahead and watch the mock mediation video that I've posted, and then go ahead and post some comments in the forum on Twen concerning attorney conduct related to the mediation that you're going to watch. Okay? All right, so our discussion for this week is the introduction to mediation. And here in Florida in particular, we have lots of different sources of information, authorities, if you will, concerning what the mediation process is. We have both the Florida rules for mediators. Actually, it's the Florida rules for certified and court-appointed mediators, specifically Rule 10.210, which describes mediation in one way. And you've got that there on the screen. And then, of course, the Florida legislature has weighed in Florida statute section 44.1011 with its own definition. If you look at both of those definitions, you can see that they have a lot of overlap. But the gist of it is that mediation is a process where there's a neutral third party who does not have the ability to make decisions about what the outcome should be, but who tries to help persuade the parties to reach a voluntary resolution of their own rather than the parties having to go on to court. All right. So why do folks mediate? Well, first off, it's a collaborative process. Both sides actually get to work together to try to fashion an outcome that might work for both of them. And another reason why they do mediation instead of just simply negotiation is because that neutral third person can help facilitate the negotiation. Often mediation happens after the parties have tried to negotiate themselves, but weren't able to reach a deal just on their own. Having a neutral third party there means that when the mediator may play devil's advocate or may ask some questions that may be challenging of the positions that a party takes, there isn't that immediate reactive devaluation that might happen when the other side makes those same sorts of points. Instead, when it's the neutral who's asking, sometimes that means that people are willing to be a little more open-minded about what actually the concerns may be. Why else do folks mediate? Well, because parties decide. Listen, a lot of individuals they say that they'd rather have the judge or a jury make a decision because at least at some levels they want to feel as if their thoughts are validated by that outcome. And of course, the difficulty with that concern is that juries and judges are unpredictable. And as a result, they may not get the satisfaction that they think they would get, the parties might, if they actually go into court. Whereas parties making decisions about important matters like these tend to be, they get the chance to fashion something that they're willing to live with, rather than simply accepting whatever the 6 strangers who stand in line behind you at 7-Eleven decide should be your fate. Why else do folks mediate? Well, because mediation is confidential. The discussions are done in a confidential setting. If there's dirty laundry to be aired, it doesn't have to be aired in a setting where everyone hears it. It's just a matter that the either parties or opposing counsel may need to hear those sorts of things. And the reality is sometimes there's stuff you got to say or concessions you might be willing to make, but only if they're done in confidence rather than with everyone else and their uncle being able to know what's going on. Why else do folks mediate? Well, they're very low cost. Soup to nuts, a piece um, of state court, circuit court litigation, something along those lines, can easily cost each side between $30 and $60 to $75,000 in attorney's fees and costs. Easily, sometimes it's more. Federal court, it's typically $75 to $150,000 in fees and costs. And let's be clear, that's per side versus, and that's over the time frame of a year or two, which goes to the next point, which is the mediation can be quick. Mediation is very low cost and quick because the reality is, even if you may have done some discovery beforehand, you can get the whole case wrapped up in an afternoon. And so, yeah, you may have to pay the mediator's fees, and the mediator's fees may be pricey. Mine are, for example. But still, that's a lot less money than if the parties had to keep slogging through the litigation process and going all the way to court and then thereafter. So these are among the principal reasons why parties might choose to mediate the dispute. Oh, and of course, the last thing that's not listed here, but probably should be, is the recognition that why else do folks mediate? Because sometimes the judge makes them. I say sometimes, the reality is better than 90% of all civil actions in Florida are referred to mediation at one point or another during the course of the piece of litigation. So these reasons that are listed here, these 6 reasons on the slide, are why they may choose to, but then of course the judge may make them too. So how do cases get to mediation? Well, we've got the 4 different ways listed here. First is by court order, and as I say, that is very common. And that's where a court, or if it's a matter that's administrative matter that's pending before an administrative agency, either the court or the administrative agency enters an order of referral of the case to mediation, and then either after the parties have had a chance to choose a mediator, or if the parties don't choose one on their own, the court then appoints the mediator to handle that case. How else do cases get to mediation? Well, they can get to mediation by agreement. And this can happen either pre-suit, it can happen when they file a stipulation asking the court to refer it to mediation, or it can be a so-called private mediation, which is where, irrespective of whether there is a lawsuit pending, they don't get the court involved in having it referred to mediation. They just pick up the phone and say, hey, Shulman, will you mediate this case? Or insert name of mediator here. How else do cases get to mediation? Well, there are some Florida statutes, as well as a couple of administrative regulations, that require mediation at certain stages. One of the ones that I've listed here is Florida Statute Section 720.311, which requires pre-suit mediation of all homeowner association disputes. And the legislature has built in a penalty because while normally the parties who prevail in litigation under the HOA statutes are entitled to a reasonable attorney's fee on top of whatever other relief they're given, if a party fails to mediate beforehand, not fails to reach an agreement, but fails to mediate beforehand, they lose that right to recover the attorney's fees they otherwise would be entitled to. The other thing I want to point out is that both the state courts and the federal courts have local rules concerning, well, strike that. The state courts have rules of procedure, and I've listed them there, 1.700, 1.710, 1720, 1730, and if you're in county civil court, 1750. These rules of procedure directly discuss how cases get to mediation, as well as the additional procedural requirements related to a court-ordered mediation. The federal courts have local rules, and the Middle District has relatively new local rules. They revamped them about 3 years ago, 2-3 years ago. But the gist of it is lots of the same sorts of requirements in terms of who has to show up and what authority the mediator may have. Here's an overview. As you folks will recall from other lectures, I'm a fan of the PowerPoint flowcharting tool. But here's an overview of the court-ordered referral process in state court, right? So in the upper left-hand corner, you're starting with the order of referral to mediation. The first decision point is whether either side chooses to file a motion to dispense with mediation, okay? And there are a variety of reasons why people might choose to assert that, including the parties have already mediated, or that the mediation is unlikely to yield it with a deal, or that a party can't afford mediation, that kind of stuff. And I've next to that one decision point, I put the word no with an asterisk. And the reason for that is I'm essentially saying they are either no, no motion was filed, or no, the court heard a motion and denied it, and instead the case is going on to mediation. Um, I will tell you my experience is that the courts generally are going to deny those motions to dispense with mediation, especially if the parties say it's just not likely to yield a deal. The courts don't believe that generally. The fact that parties have mediated in the past, the question frequently brought up in those hearings is, well, how recently? If you mediated pre-suit, or if you mediated, 6, 9 months ago, the court's probably going to say, yeah, stuff's happened since then, go to mediation. If you mediated last week, the court might not, right? The court might say, okay, fine, I'm not going to make you spend the money again. Although sometimes they will, and they'll just say use a different mediator. In terms of the inability of a client to afford the mediation fees, I've seen the court handle that in a couple of different ways. In some cases, I've seen the court direct the attorney to bear the expense and just simply, seek to recover that from the client if and when the client can pay. In other instances, I've seen the court simply just deny it out of hand. That's not a reason. And finally, sometimes I've seen the court either adjust the fees, mean that it's not more than a certain amount per hour or total, or requiring the other party to pay the entire amount. And then as part of the order, that party can then tax the entire cost of the mediation against the opposing party, or at least the part that they laid out, assuming that they win at the end of the case. Okay. So that's the first place is there a motion to dispense with mediation? If there is not such a motion or it's denied, then it goes to the next decision point, which is, can the parties agree on a mediator within 10 days? If they do, then great. It goes straight down to the lower right, mediation is held. If they don't agree on a mediator, then the court appoints a mediator. And that mediator whom the court appoints has to be a mediator who is certified in that area of mediation. So for example, if it's a county civil action, it has to be a certified county mediator who's appointed. If it's a circuit civil action, it has to be a certified circuit civil mediator. And typically under those circumstances, the court will also identify what the fees should be. But if they don't identify what the fees, then you'll want to talk with the mediator about how much they intend to charge. After the court appoints the mediator, but before the mediation, there is the opportunity for the parties to object either to the mediator or to the fees the mediator proposes to charge. And bases to object to a mediator are they're pretty wide, but the most common is simply that they think the mediator has too much of a connection to the dispute or to one of the parties or something like that, such that they have a conflict of interest that the party's not willing to waive. Or if the mediator charges too much, the mediator, like the parties can file a motion with the court asking the court to direct the mediator to charge less. Now, if that's the case, the mediator can decline the appointment, or the mediator can take that mediation at the reduced rate, either one. But in any event, if the court kicks the mediator off because of a party objection, then the court appoints another mediator, that sort of thing, and you go through that process. Eventually, if there is no motion concerning an objection to the mediator or to the fees the mediator wants to charge, then you go across this bottom line and yay, hooray, the mediation itself is held. Now, I want to digress briefly and talk about who can be a mediator. In mediation, anyone can serve as the mediator in these court-referred mediations by agreement of the parties. And I say that because mediation certification here in Florida, it's not a license. It's not like you have to be licensed to practice law or medicine. Instead, certification simply means that people have taken training in that area of the mediation and have demonstrated sufficient experience as well as gone through a mentorship process so that the Florida Supreme Court is satisfied that they can conduct those kinds of mediation. And the court can only require, a local court can only require you to mediate before a court, before a certified mediator. And I've listed the types of mediator certifications that we have here in Florida. Another thing to keep in mind is that since 2008, you have not had to be a Florida lawyer in order to be certified as a circuit civil mediator. So if you're a lawyer and you're in circuit court and there's a mediation and you think your mediator should be a lawyer, you can tell that to the court and ask the court by rule. You can ask the court to appoint only circuit civil mediators who are attorneys. All right. Now, who must appear at mediation? Because that's what Rule 1.720 says. It talks about who must appear at a court-ordered mediation. If it's court-referred mediation, as I said, Rule 1720, specifically B, talks about who has to be there. The small claims court action, then Florida Rule Civil Procedure 1.750E tells you who has to be there, as well as Florida Small Claims Rule 7.090. In county civil or circuit civil court, there are 3 different types of people who have to attend the mediation on each side as applicable. The parties, or if it's a non-human party like a company or something like that, there has to be a person with authority to decide without further consultation at any mediation. So there's got to be the party, there's got to be counsel, assume that there is counsel on the case. And if there's insurance that can answer any of the claims, there has to be an insurance adjuster who appears at mediation with the ability to settle claims up to the lesser of the amount of coverage under the insurance policy or the plaintiff's last demand, right? So these people all have to attend mediation. And in fact, you lawyers are required to file a certificate with the court identifying who's going to be at the mediation that's been court ordered and with the authority that's required by rule. And here's a gotcha moment. Failure to file that certificate is prima facie evidence that the people who attended mediation did not have the authority that the rule requires. And that can be the basis for a motion for sanctions brought by the other side if mediation doesn't seal the deal. So this slide talks about who must appear at mediation. And the question is, well, what does that mean, right? So the good news is that appearance literally means just show up and attend the mediation. And in fact, with a relatively recent Florida Supreme Court rule change, appearing can be by Zoom if the parties agree. Be by telephone or Zoom if the parties agree, as opposed to the old way, which was you had to actually show up in person unless there was a court order that allowed it to be by Zoom. Now the rule says the parties can simply agree to do that, and if they want to, that's fine. What does appear mean? Well, I've given you the citation to Carbino versus Ward. You're welcome to take a look at the case. The gist of it is that all you have to do is show up. I'm sorry, strike that. The Carbino versus Ward case is a little bit stands for a different proposition, but all generally you have to do is show up. You don't have to make any offers. You don't have to accept what the other side is offering or anything along those lines. You just got to show up. Carbino versus Ward stands for the proposition that even if you've got a situation where one of the people who have to be there aren't going to do anything to try to settle the case, you still have to go to mediation. The facts on Carbino versus Ward was you had a run-of-the-mill personal injury automobile accident case, and the defendant driver didn't have 2 pennies to rub together, had no money, wasn't going to contribute anything, and had some personal matter come up, and told their lawyer that this had come up and asked if they had to go to mediation. The lawyer said, "Don't worry about it, you don't have to go." The difficulty there is the lawyer didn't ask the court to excuse the defendant. The mediation happens, and insurance company and insurance defense counsel show up. It doesn't settle. After that, the plaintiff moves for a sanction and gets it from the court because the defendant did not show in person. Now, I want to be clear, this was not just a mother may I situation, right? because you didn't ask for permission, you don't get to ask for forgiveness later. Instead, the Fifth DCA went on to explain that the reason why they have to be there is because it's the defendant who has to deal with the consequences of there being no deal, not just the insurer. Because there's a possibility, if there is no settlement, that there's ultimately a judgment against the defendant that exceeds the amount of available insurance proceeds, and the defendant himself is on the hook for that excess judgment. So the defendant might want to be there at the mediation and see what, if anything, the defendant can do, either to needle the insurance company to pay more or to kick in something of their own in order to sweeten the pot to try to get a deal. Now, all that stuff I've talked about so far there about who must appear only matters if it's a court-appointed mediation. If it's not a court-referred mediation, so-called private mediation, then who has to appear? Whoever does that the parties are willing to move forward. Okay, so here is a brief overview of the mediation process itself, right? We've gone from first getting to the mediation, now Shazam, you're at the mediation itself. And it starts in the upper left-hand corner with the mediator opening. And that's where the mediator spends some time, maybe 5 to 10 minutes, discussing the mediation process, discussing mediation confidentiality, discussing what the mediator can do, what the mediator can't do, talking about what the parties can and can't do in connection with the mediation process. When the mediator's done, then the lawyers get to have do their opening statements on behalf of their clients. I've got it listed as parties' opening statements. I'll tell you that generally, unless you have a client who absolutely has to say something, and I'll generally try to get you to discourage your clients from doing that in real life. Typically, it's just the lawyers who are doing the opening statements because the lawyers are trained in how to do that, whereas the parties may give away more information than perhaps you as their counsel might want them to during the opening. Having said that, if your client is sophisticated, then there's nothing wrong with you do the legal part of it, and then they do maybe some of the facts, or maybe they tell how it affected them, or something along those lines. I'll leave that to your discretion. After the parties do their openings, then the mediator may ask some questions. This next portion is called mediator frames the agenda. And what the mediator is doing there is going over what the mediator heard during the opening statements from each side, helping identify areas of agreement, confirming that the mediator understands where the areas of disagreement are. Typically, the mediator will also at this stage ask, if they don't already know, what the procedural posture is of the case. Is this pre-suit? Is it early in the suit and all that's been done is paper discovery, but you haven't taken depots? Or is discovery done and there's a motion for summary judgment pending? Or those sorts of things. Mediator will also typically ask for what the negotiation history is between the two sides. And the mediator is doing this for a couple of reasons. The first reason is to just get a sense of where the parties are likely to start today in the mediation. And second, because the mediator wants to know whose turn it is, right? By that, I mean whose turn it is to make the next offer or response. Usually, if there have been no earlier negotiations between the parties, the party that's asking for affirmative relief, the plaintiff, the claimant, that's the person who's expected to make the first offer. But if during their opening statement, or if prior to mediation, they've made an offer and there hasn't been a response from the other side, then guess what? The mediator is likely to start with a defense and say, okay, what's the response to that offer? And the mediator may talk about these offers and may discuss these with both parties still together in the same room. And I guess I should mention that. That's frequently the way that this is all playing out at the beginning of the mediation. You, your client, the other side, and the mediator are all in one room together while that happens. And so the mediator can lead a discussion between the two sides, all in the same room, about offers or counteroffers the parties are going to make to each other, about alternatives. The mediator may ask questions, may probe areas of risk of loss, that kind of stuff. But most mediators, instead of doing that in continued joint session, will break the parties apart into caucuses, into private meetings. And those private meetings are just that. They're meetings where the mediator is not allowed to share what's discussed in that room with the other side unless you give them, or more likely, your client gives them permission to do so. Although, of course, you can typically speak on your client's behalf there. And so in many mediations, the format is the parties start together, they do their openings, and then the parties split up, and the mediator bounces back and forth between the two rooms, and really don't get back together until the very end, or if at all. Sometimes, though, the mediator will keep the parties working together, and then when it looks like things are starting to go off the rails a little bit, that's when the mediator will split them up. May eventually, when it looks like they're playing nice again, bring the parties back together. It depends. It's a mediator discretion sort of matter, and the mediator is going to change his or her practice frequently based on what that particular mediation seems to need. Because while this is the overall process, it's kind of like mediations are sort of like boxes of chocolates, like in the movie Forrest Gump, right? Life's like a box of chocolates, and so is mediation. They're all the same, but you don't know what you're going to get. So there you go. In any event, eventually the mediation itself ends, and it ends in one of three ways. It can end with the parties reaching an agreement, yay, hooray, in which case it'll get written up and signed. It can yield an impasse, which is not necessarily a bad thing. Impasse is not a four-letter word, for example. But just for whatever reason, y'all were not able to cross the finish line and get a deal. Or a mediation can end with an adjournment. And an adjournment is, well, you got as far as you could today, but you contemplate sitting back down at the table again at some time in the future. Common reasons for adjournment instead of an impasse might be, let's say that one of the big differences between the two sides has to do with maybe there's a key witness whose deposition needs to be taken. Maybe there's a motion pending that will resolve all or some of the complaint, or some of the claims, and so you want to get that decision before making a decision about whether and under what terms to settle the dispute. In any event, those are among the most common times that you'll see adjournment. And then thereafter, you, of course, as the lawyer, have some follow-up. If there's an agreement, you'll usually have to file a stipulation for dismissal that you and the opposing side have signed. If it's an impasse, well, congratulations, you get the rest of the litigation to work on. If it's an adjournment, well, you're going to do whatever you need to do in the interim and then get ready for another mediation thereafter. At the same time, at the end of the mediation, the mediator is going to file his or her mediator's report with the court, if it's a court mediation, identifying to the court whether there was a deal, no deal, or adjourn. Okay? All right. Oh, and by the way, mediation is confidential, as we'll talk about at some length momentarily. And as I've suggested before, that's one of the key advantages of mediation as a process. The parties can just have private conversations, including private caucus conversations that need to have just to understand why it really makes it better for the parties to settle at mediation than perhaps taking the chances at court. Okay? All right. So what I want to do now is cover briefly some of the features of mediation confidentiality. First off, there are two sources of mediation confidentiality here in Florida. The first applies to certified or Florida court-appointed mediators, and that's Florida Rule of Mediation 10.360, which is the mediator ethics rule that says mediator may only disclose mediation communications when they either have the consent of the parties or there's an exception to the law that allows. There's an additional subdivision of that rule that requires the mediator to maintain the confidentiality of the caucus's private. Florida Rule of Mediators only applies to the mediator. The next bit, Florida Mediation Confidentiality and Privilege Act, Florida Statutes Section 44.401 through 44.406, that applies to everyone who's involved in the mediation process. The mediator, the lawyers, the clients, the insurer, anyone else who attends the mediation with party consent. Okay? This act applies to all of them. Let's talk about some of the specifics there. And you've got these materials. In fact, I believe I assigned you to read those 6 sections of the Florida statutes as part of your preparation for this week, but just an overview of some of those things. The meat of it is the confidentiality and privilege provision, 44.405 sub 1 and sub 2. Sub 1 is confidentiality, sub 2 is privilege. And the principal difference between these two is just like you learned in PR, the difference between attorney-client privilege, that's an evidentiary concern, and talks about whether information can be presented to a court versus attorney-client confidentiality, which is whether the attorney can tell anybody, regardless of whether the court proceeding, about what's discussed there. Well, likewise, Mediation Confidentiality and Privilege Act, mediation confidentiality is that mediation participants, or essentially anyone who's there, can't disclose what's said at mediation to anyone else other than someone else who was there or their counsel. The privilege is, as the rule, as the statute indicates, limits the ability for anyone to testify about what was discussed at a mediation unless there's an exception. And the exceptions are all the same, so we're going to talk about all the exceptions, whether it's for confidentiality or for privilege. While the statute doesn't call them this, I sort of think about the exceptions to confidentiality and privilege under the Act as being general purpose exceptions and then limited purpose exceptions. The general purpose exceptions to confidentiality, first off, unless agreed otherwise, the settlement agreement itself isn't confidential. So once mediation is done and the parties have reached an agreement, unless they say we're going to keep this agreement confidential, it's fair game. There's no limitation on disclosure of what that agreement might be. Additionally, whenever mediation communications, well, first, if the parties have waived, all the parties have waived confidentiality or privilege, then shazam, it's not confidential or privileged. Go figure. Secondly, when the information at mediation is willfully used to plan a crime, commit or attempt to commit a crime, conceal ongoing criminal activity, or threaten violence, right? All those things listed in the statute, those are by definition exceptions to confidentiality. And if you read the legislative history, that was actually put in there by the Association of States Attorneys here in Florida because of concerns that the criminals could hire a mediator. The mediator would convene a mediation under the Act, and then they could use that to plot criminal conspiracy or the like, or to engage in an actual crime, and that there would never, the prosecutors wouldn't be able to prove the case up in court because of this. There are exceptions provided. Those are the only general exceptions: the agreement, waiver, or criminal stuff. And it's not all criminal stuff; it's just the things that are listed there. The situationally limited exceptions are these. And by I say limited, I mean they are limited just to that context. So for example, the first one is a mandatory report pursuant to Chapter 39 or Chapter 415 of the Florida statutes. Chapter 39, the provision there has to do with child abuse or neglect. Chapter 415 deals with the abuse, neglect, or exploitation of the elderly or other vulnerable adults. Okay? Professional malpractice or misconduct that occurs during the mediation. Remember, the distinction between malpractice is oopsie, right? The attorney or other professional made a mistake in what they did or said, versus professional misconduct is an ethics violation. One of the most common things that we talk about in that regard is an attorney who refuses to honor the client's direction as to whether and under what terms to settle the claim. And then the attorney says, no, we're not going to do that. I'm not going to let you. That's an attorney ethics violation. And there's an exception to confidentiality and privilege for that. Additionally, there is an exception to confidentiality and privilege when the information is offered for the purpose to avoid or reform a mediated settlement agreement. Okay? This last one is sort of recognizing that the courts were already doing that. You know, if a party goes to mediation and isn't happy with the agreement that's reached, they can ask the court to set it aside on the typical bases that you could set any contract aside: duress, misrepresentation, that kind of stuff. Well, how would the court take evidence on that unless they were able to hear what happened at mediation, right? So there's an exception that allows that. And I said these were limited circumstance, limited setting exceptions. And by that, I mean, there are exceptions for you to report or respond to reports in each of these instances. But that doesn't mean that you could go ahead and go to the local newspaper and say, boy, you won't believe what happened at mediation, right? Instead, the exception is simply in the context of making the specific report that the exception identifies. Finally, the Mediation Confidentiality and Privilege Act, at least the confidentiality part of it, has some teeth. In the event that the mediation is court ordered, then under Florida 44.405 sub 1, the court may impose sanctions against the party who breaches confidentiality. And the list of what those things could be are there. If, in addition to that, whether the matter is a court-ordered mediation, if the act otherwise applies, then a party who is harmed by a breach of confidentiality has a civil remedy pursuant to Florida Statute 406, 44.406, but it doesn't have to be a court-ordered mediation. Instead, the injured party brings an action, an independent action in court, alleging violation of the civil remedy. Okay? All right, folks. So that's been my quick overview of the mediation process. We will, of course, be talking much more about your role as counsel moving forward, but that's all for this